In today's video, we're going to go through the visa determination process in Australia. So step one of the process is to assess whether you qualify as a refugee or for complementary protection. The definition of refugee under Australian law is defined as a person with a well-founded fear of persecution from their country of origin and who is unable or unwilling to return to that country due to that fear. This persecution fear could be due to your race, religion, nationality, political opinion, or membership of a particular social group. And there's a real chance that you'll be persecuted for one or more of these reasons. It must also be shown that the person can't relocate to another part of their country to avoid that persecution, that there are no effective ways that they can protect themselves from that persecution, and that they can't reasonably be expected to modify their behaviour, appearance, or be forced to do a certain thing in order to avoid that persecution. The criteria for complementary protection is if a person seeking asylum doesn't satisfy the definition of a refugee, a person will be automatically considered against the complementary protection criteria. This means that they may still be granted a protection visa if they face a real risk of significant harm in their home country. A very important note is you must provide genuine documents. If you satisfy the definition of a refugee or meet the complementary protection criteria, your application might be refused if you provide the department documents that aren't genuine or if you destroy or dispose of your genuine documents. A person might not be granted a protection visa even if they satisfy the definition of a refugee if they have a serious criminal record before or during their application for their protection visa, or if they're considered a risk to the community. Step 2. Review the types of visas for which you might be eligible. This will depend on how you arrived in Australia. If you arrive by boat, you might not be able to remain in Australia due to offshore processing. If you arrive by plane with a valid visa and are immigration cleared, you're eligible for a permanent protection visa. If you arrive by plane without being cleared by immigration, you could apply for a temporary protection visa or a safe haven enterprise visa. These are also known as TPVs and SHEVs. How should you choose between a TPV and a SHEV? A TPV is a 3-year visa, allowing you to study and work in Australia and access limited Centrelink benefits. A SHEV is a 5-year visa. You can also study and work in Australia, but if you want to meet the pathway requirements, you need to be employed or studying while living in regional Australia. This visa also allows you to access limited Centrelink benefits. But if you want to meet the pathway requirements, you can't access some payments. What happens when your visa expires? If you're a TPV or SHEV holder who first arrived in Australia on or after the 14th of February 2023, you can apply for a subsequent TPV or SHEV. To remain lawful, you must apply before the TPV or SHEV expires. TPV or SHEV holders who arrived in Australia before 14th of February 2023 are eligible to apply for a permanent resolution of status visa, also known as a ROS. It's recommended that you obtain independent legal advice and/or migration advice before attempting to apply for any of these visas. If you have any other visa options aside from a protection visa, for example, a family or skilled visa option, then it's important that you get migration advice about those options before you apply for a protection visa. Step 3. Prepare documents according to the visa you would like to apply for. At this stage, depending on the specific visa you wish to apply for, you may need to prepare the following documents. First, identity documents. This might include your passport and birth certificate or national identity card. The second type of documents that you'll need are evidence supporting your visa application. Relevant documents that support your claims or circumstances, such as employment records, educational qualifications, or family ties in Australia, might help with this. Health and character documents. Medical examination results and police clearance certificates might be helpful for this. The next type of documents you might need are financial documents. This includes proof of financial capacity, such as bank statements or employment contracts. You might need previous visa documents as well. This includes details of any prior visas you've held or any associated documentation. Step 4 is to lodge an application with the Department of Home Affairs in IMI account. That's the online portal where you'll lodge a visa application. Now you're at the initial application stage. To submit a valid application for a protection visa, you'll have to complete and lodge a Form 866 for a PPV, a 785 for a TPV, a 790 for a SHEV, an 851 for a ROS. You can access these forms online, but you'll generally need to submit the application via your IMI account. You may be invited to attend an interview with a department delegate. The delegate will ask you questions about your application and why you can't return to your home country. The delegate will determine whether you need to submit any further documents. If your application is accepted, your visa will not be granted until you have satisfied health, security, and character checks. The department will contact you to arrange to have these checks done. You'll likely need to undergo some specific medical checks, but you can't be refused a protection visa if you have a health condition. Most applicants have to pay for these tests themselves. In undergoing the character checks, the department will undertake its own checks by searching your details on national or even international databases to determine if you have engaged in criminal activity. You'll also likely be requested to provide police clearance certificates for any country you've lived in for more than 12 months within the past 10 years, except for the country against which you are seeking asylum. Step 5. If your visa application is refused, you'll enter the merits review stage. If your application for protection is rejected by the department, you can have the decision appealed at the Administrative Reviews Tribunal, or the ART. Generally, if you're living in the community, you must apply to the ART within 28 days from the date you were notified of the department decision. If you're in detention, you must apply to the ART within 7 days of being notified. However, different deadlines apply if your visa is refused on character grounds. Consider submitting a new statement or supporting evidence. Attend a hearing before an ART member to discuss your claims. At the hearing, an ART member will ask you questions about your application. You'll have to provide evidence to demonstrate that the decision of the department was incorrect. The hearing is closed to the public and you have the right to an interpreter. Step 6. If your visa still gets refused, you'll enter the judicial review stage. If you're unsuccessful at the ART, then you have limited options to be granted a protection visa, and you might want to think about making other plans, as you may not be able to remain in Australia. If there have been legal errors made by the ART which could have changed the outcome of your application, you might be able to apply for judicial review to the Federal Circuit and Family Court of Australia, or the FCOA, within 35 days from the date of your decision. The court will hear from both sides. That'll be you as a self-represented litigant, or you and your lawyer up against the government's lawyers, and then make a decision about whether your case will be dismissed. You might also be reconsidered by the ART. If you're successful, your case is sent back to the ART for reassessment of your protection visa. If you're not successful at the Federal Circuit Court, you have 3 key options. The first is to appeal to the Federal Court of Australia, or the FCA. This has to be done within 28 days from the date of the judgment, or the date on which leave to appeal was granted. Second, you might make a request for ministerial intervention. Or third, you can return to your country of origin voluntarily.